Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm reviewing an excellent book from Globe Law and Business. We're delighted to review these works. They are of a very high quality, they're very well researched, of academic brilliance, and I think a great help to the ongoing debate, if I can use that phrase, the ongoing issues which we are looking at in the late 2016, early 2017 months, concerning the way we're going with the way we run our legal businesses. This book is called Legal Risk Management, Governance and Compliance. It's very much part of what's been with us now for a couple of decades, the concept of governance, the concept of regulation, and generally complying and making sure that you act within the rules that are set down. There are some who complain and say there's far too much regulation. I'm one of them because I do think it's gone a little bit too far. However, we do need to know what our obligations are professionally, and this book is one of a number that help us. What we've got with it is that it's in an interdisciplinary series of case studies from leading experts under the editorship, the consulting editorship of Stuart Weinstein and Charles Wild. Now, Elizabeth and I thought about this book and had a discussion about it, and we've given it for our book review title, which has appeared in a number of journals already, so do have a look at the edited versions in the journals. We've given it the title Global Brands, Case Studies on Risk Management, Governance and Compliance, the latest title from Globe Law and Business. Now let's just have a look at the book quickly. It's a hardback. It's not a heavy book. There's the spine. You can probably see that. I'll bring it back a bit. And then you can see the basic information in the book. I'll just move it back a bit and then I'll come in a bit nearer. There we go. As I say, it's very much the house style of Globe Law. It's a very nice, very well published and printed book. It's just under 200 pages. There's no index at the back. This is just some information about the authors right at the back. So the structure is slightly different from what you would normally have. You do have footnoting, which you can see at the bottom of the pages there. And you do have, as when you have the title of a particular contribution, you've then got the name of the person. But there isn't any actual paragraph numbering. There's the front page there. And then after that we get into the content. There's the general blurb and then we get the contents. You see the structure. It starts off with Brexit and legal risk, a case study in the making, which is kicking off very much a book for 2017 onwards. I'm just actually reviewing this in the early part of 2017. We wrote the review just before Christmas. That's the preface at the beginning. Do read the preface. Then we go straight into Brexit, and then it runs all the way through, and you can see the structure of the book in the middle. As I said, there is some paragraph numbering in some of the chapters, but not all. Now, what do we say about the book? Well, we say this: anyone involved in risk management, and who isn't these days, should get this book, in our opinion. In this case, to be precise, the area under scrutiny is legal risk management. An important area. I used to teach it, certainly in the pre-CFA days. It's very important to see how much risk a firm is going to actually undertake. But it's the scrutiny of legal risk management which is at stake, together with the governance and compliance which we now have, as the title indicates. It's published, as I say, recently in 2016 by Globe Law and Business. I'm recording this as we begin to see Brexit unfolding, and we're beginning to see what is going to happen and how the government are going to approach it, and what's going to happen certainly within the European Union and internationally. It's a collection of articles by internationally recognised experts on carefully selected case studies, each based on rigorous research, and each what I think is a riveting and often sobering narrative of the triumphs and disasters resulting respectively from triumphantly good or disastrously bad risk management practices. And that really is the basis. I think anybody who's within senior management in a large law firm will find this very helpful, because again, risk management practices are very, very important. The salutary lessons in every chapter amply illustrate what and what not to do in planning and implementing an effective risk management strategy. And of course, you've got to have one. Whatever. I mean, I have one even for my chambers. I have to work out what sort of policies I'm going to adopt for any particular thing, because there is a certain amount of pro bono work that I do and a certain amount of other things that I will consider. But taking on board a risk or a punt or whatever you want to call it, it can be quite disastrous because you can spend a lot of time on it and get no financial reward back. So therefore one has to think very carefully about what you do. And of course, as I say, it's actually the planning and implementation which is the main thing. The book kicks off with the biggest and most compelling case study of them all, one which which will have world-changing consequences and yet has still not that much by way of resolution, and that's Britain's momentous decision to leave the EU. Now, the two editors, Weinstein and Weil, together with Matthew Wally, refer to it as Brexit and Legal Risk, a case study in the making. And it certainly is. It's unfolding as I speak, even now at the beginning of 2017. We've had Mrs May's statement giving an indication. We've got the Supreme Court ruling about to be announced next week. And it's quite clear that Parliament will be involved, and there is a proper timetable. The words used by the Prime Minister are not the same, of course, as the words used by the press, which is always quite interesting. Then it goes, of course, too, for legal journals. However, I do think it's worth reading that very first chapter in the book, because Brexit is with us, and it's a big thing. It's a big thing, this one. It's fair to say, then, that each of the case studies covered holds its own special fascination for us. Take, for example, the scandal of FIFA and the high-profile investigations concerning its governance, in which any corporate governance is, of course, the key issue. Now, you can say what you like about it, but there have been many commentaries about FIFA and the behaviour. And I'll leave it to you to decide what you think. I certainly know what my thoughts are. Analytically, of course, it's discussed here is the intervention by the US Department of Justice in the form of a 47-count indictment against 14 defendants, including one in particular at the top of the tree. So you've got some idea of the way the Americans are looking at it. And of course, it's serious because we are talking big money here. We're talking about international influence. And it does in the past, it has set off wars. So we've got to be very careful what we do. The further discussions, and I'm not being too dramatic, of course, the further discussions on compliance issues include an article on aviation safety considerations, including flight path monitoring, flight into terrain. It's now called that, FIT. I knew it as something else. I knew it as TRR, but we know it now as FIT. And then the approach and landing, it's the ALA accidents, which, say the editors, have been targeted as being amongst the primary killers in the aviation world. That, of course, for anybody who is a flyer will identify that. Better not read this if you're planning, therefore, to fly anywhere anytime soon. And don't worry, we have a very, very safe record, and flying is lovely. Compliance issues also arise in the terse and information-rich discussion of the case of the Attorney General of the State of New York and Barclays Capital Incorporated, a rather complex matter, I have to say, involving technology-based marketing of securities in contravention of an anti-fraud statute known as the Martin Act. The article describes the ramifications and the consequences, not to mention the eventual costly outcome. And with its focus on cases involving big international brands and big money, and the resulting diverse array of insights and revelations, the book should provide, we think, an eye-opener to practitioners, particularly international lawyers, and indeed anyone involved in the management of legal risk in both the private and public sectors, and the non-profit sector as well. And finally, let me say, note that the book is also intended as a case study companion to Globe's previously published bestseller, Legal Risk Management, Governance and Compliance, A Guide to Best Practice. And the publication date is cited as at 2016. This is the book again. Let's just have a quick look at it. There's the front, and then there's the back again, the spine and the back. Just opening it in the middle, you can see, for instance, this is one I'm just opening up. I'm just going to get to it. It's Linda Spedding's article, Legal Risk Management and Responsible Business, the Sachin India case. There we go. So you see you have a very wide area of jurisdictions covered. I'd like to thank all the people at Globe, that Sean O'Neill and Nicola Hornby, and everybody involved, including the people who've produced this book, for what is an excellent work. Thank you to all concerned. I'm most grateful for this as another excellent book in the series. Thank you to all. Bye-bye.